What's up, everybody? I'm back, and I'm continuing to go over what was being printed in the press at the time of Stephen Avery and Brendan Dassey's arrest, and what was being printed at the time their trial was going on, and eventually everything that happened post-trial as well. Today we are going back to March 2nd, 2007, and this article is from the Madison, Wisconsin State Journal. The article states, Avery prosecutors link gun to victim's DNA. Prosecutors trying Stephen Avery for murder linked a gun found in his bedroom to a bullet with the victim's DNA on it Thursday, and had an anthropologist testify that bone fragments found in Avery's yard were likely burned in that spot. In November of 2005, deputies seized a .22 caliber rifle and a .50 caliber muzzle loader with Avery's first name taped on it from a rack over Stephen Avery's bed. 2 bullets were found in Avery's garage during a second round of searches on the property in March of 2006. A gun expert with the state crime lab said he couldn't conclusively link a bullet found in a crack in Avery's garage to a .22 caliber rifle seized from his bedroom, but the bullet found under an air compressor in Avery's garage was likely fired from it. That was the bullet that a state DNA expert said had hull box remnants on it. He testified that bullet could not have been fired from any other gun. He also said that all 11 shell casings found in Avery's garage were fired from the .22 caliber rifle. Earlier, a forensic anthropologist said bones she examined were likely burned in the dirt pit behind Avery's garage. Then some were moved to a burn barrel near Stephen Avery's sister's trailer on that property. The next article is from March 3rd, 2007, and is from the Madison, Wisconsin State Journal. The article states, Avery lawyers want blood tested. 3 weeks into testimony in Stephen Avery's murder trial, his lawyers want a mistrial or a month-long continuance so that an independent and unproven test can be done on a blood vial and blood stains at the center of their case. Manitowoc County Circuit Court judge scheduled a hearing Monday on the defense motion that seeks to have testing done at state expense to determine if the blood stains in the victim's vehicle had a preservative that would indicate that it came from a stored vial of Avery's blood from a previous case. The next article is from March 6, 2007, and it is from the Madison, Wisconsin State Journal. Testimony on blood in Avery trial allowed. Judge rejects a request for a mistrial or delay for additional tests on the blood. Of course he did. A judge on Monday decided to allow testimony from an FBI witness who said tests showed that a vial of Stephen Avery's blood could not have been planted as evidence against him. Judge Patrick Willis also ruled against a defense request for a mistrial or delay of several months so the defense could conduct tests on the blood. He also ruled against a request to use public money for the test. Avery's attorneys claim deputies used a vial of blood found unsealed in the county courthouse to plant blood in the vehicle because they were ashamed about the lawsuit and convinced Avery murdered Teresa Halbach. The 11-year-old vial was left over from Avery's appeal of his convictions. Chief of the chemistry unit at the FBI lab in Virginia testified Monday outside the presence of the jury that he thought the blood found in Teresa Halbach's vehicle did not come from the vial because the stains did not contain a blood preservative called EDTA that was in the vial. Defense attorney Dean Strang argued that he could not say how much the sample degraded from 2005 until it was tested in 2006, and it is suspicious that the preservative wasn't found in controlled samples given its prevalence in the environment. Willis ruled against the mistrial and delay, saying Strang's arguments went to the weight of evidence and that will be decided by the jury. He also said Monday that the defense had plenty of time to test the vial on its own. The chemist from the FBI also testified Monday that his lab received 3 samples of blood found in Teresa Halbach's Toyota RAV4. He also said he tested them for EDTA, which was in the blood vial. He said his opinion was that Avery's blood stains in Halbach's vehicle did not come from the tube. On cross-examination, defense attorney Jerome Buting said the first and last time the test was done by the FBI was during the O.J. Simpson trial murder case in the mid-1990s. The FBI agent said no law enforcement agency has asked them to do it since. Buting pointed out that the protocol created by the FBI in the Simpson case was later criticized by scientists as being hastily devised. The FBI agent also admitted that no scientists outside the agency had reviewed it. The protocol is different now because the FBI office moved and has newer equipment. After court, Jerry Buting said both sides in the Simpson case were allowed to test mid-trial for EDTA. He said Willis's decision for the first time ever that a judge allowed such results to be admissible without allowing the defense to perform tests. We will review this as a Hail Mary pass by the state, Buting said. They feel their case was weak enough they needed to take a chance to build a ready-made appeal issue into the case. Gahn said the FBI expert vindicated the deputies Avery accuses of framing him. This week is the fourth week of testimony in the trial, which was expected to last around 6 weeks. 47 witnesses have testified for the prosecution so far. In the last article today, prosecution rests in Stephen Avery's case. It's from March 8th, 2007, from the Madison, Wisconsin State Journal. After 3.5 weeks of testimony, Stephen Avery's defense attorney, Dean Strang, cross-examines an arson investigator of the State Division of Criminal Investigation before the prosecution rested its case late Wednesday. He testified that the tires burned in the pit behind Avery's home where the remains of 25-year-old Teresa Hallbach were found would have made the fire burn hotter and longer. So, those are the articles we are going over today. The big one was the EDTA in the vial and comparing it to the O.J. Simpson case. What do you think? Let me know. Leave some comments below. I hope you're having a good day, and I will see you again soon.